this debate regarding the Canada-U.S.-Mexico Agreement, CUSMA, replacing the North American Free Trade Agreement that was negotiated by a previous Conservative government. To paraphrase comments previously made by my Conservative colleagues, the good news is that after rigorous debate in Parliament and in committee, Canada will continue to have a trade agreement with our largest trading partner. The bad news is that it was negotiated by the Liberal government, which made concession after concession to the United States and Mexico. The United States is our greatest ally and our largest trading partner. The NAFTA deal that was negotiated by Conservatives has been good for Canada, with $2 billion a day in trade crossing our border, which represents 75% of Canadian exports. U.S. direct investment in Canada in 2018 was over $400 billion, which is huge. Since NAFTA was first implemented, over 5 million jobs have been created, and total trilateral trade has quadrupled to $1.2 trillion. Conservative trade deals have done a good job creating jobs for Canadians. The Conservative Party of Canada is the party of free trade. An election was fought over free trade. Luckily for Canadians, Conservatives won that election. It was under former Prime Minister Brian Mulroney that the first Canada-U.S. free trade agreement was signed. Then it was under former Conservative Prime Minister Stephen Harper that Canada signed a record number of trade agreements, providing our Canadian businesses with unprecedented access to markets around the world. The Conservative Party is the party of free trade. We have long supported free trade and will continue to support a free trade agreement with our largest trading partner, the United States, and Mexico. On February 25th, I had the honor of presenting Private Members Bill C-222, an act to amend the Expropriation Act, protection of private property. There's been a disturbing trend in Canada towards what is referred to as regulatory, de facto, or constructive taking of private property. This happens when a government uses its statutory powers to regulate or restrict the property rights of an owner without acquiring title to the land being adversely affected. The landowner feels the impact of the regulation as if the land has been expropriated. In the United States, the Fifth Amendment of the American Constitution protects private property rights. In Canada, government acquisition of land without the owner's consent is not subject to the Canadian Charter of Rights and Freedoms. Private property rights were excluded from the Canadian Constitution when it was repatriated in 1982. In Canada, landowners' rights are found in the expropriation legislation. The government must follow the law as to what land may be expropriated and must observe procedures set out in the legislation. In Canada, the government can strictly regulate land, limiting its value and what a landowner can and cannot do with it without triggering the procedures in the legislation. A de facto regulatory taking means a property owner is not entitled to compensation unless the restrictions of the owner's rights are such that they should be properly regarded within the meaning of the Expropriation Act. Now, I introduced Bill C-222 to provide some protections from the government taking people's property without compensation. It would appear that CUSMA addresses the issue raised by my private member's bill, C-222. Canadian common law on de facto expropriation suffers from what some jurists refer to as external incoherence. The present context of CUSMA decries the possibility that the rights of foreign investors in Canadian property are afforded more protection than are the rights of Canadian property owners of Canadian property. The source of this incoherence is Article 1110 of the North American Free Trade Agreement, NAFTA, which has been carried over into CUSMA under Article 14.8, expropriation and compensation. Article 14.8 in the new agreement provides, 1, no party shall expropriate or nationalize a covered investment either directly or indirectly through measures equivalent to expropriation or nationalization, expropriation, except A, for a public purpose, B, in a non-discriminatory manner, C, on payment of prompt, adequate, and effective compensation in accordance with paragraphs 2, 3, and 4, and in accordance with due process of law. 2, compensation shall be paid without delay, be equivalent to the fair market value of the expropriated investment immediately before the expropriation took place, the date of expropriation, and C, not reflect on any change in value occurring because the intended expropriation had become known earlier, and D, to be fully realizable and freely transferable. 3, if the fair market value is dominated in a freely usable currency, the compensation paid shall be no less than the fair market value on the date of the expropriation, plus interest at a commercially reasonable rate for that currency accrued from the date of expropriation until the date of payment. 4, in the fair market value, if the fair market value is denominated in a currency that is not freely usable, the compensation paid, converted into the currency of a payment at the market rate of exchange prevailing on the date of the payment, shall be no less than A, the fair market value on the date of expropriation, converted into a freely usable currency at the market rate of exchange prevailing on that date, plus interest at a commercially reasonable rate for that freely usable currency accrued from the date of expropriation until the date of payment. And 5, for greater certainty whether an action or series of actions by a party constitutes an expropriation, shall be determined in accordance with paragraph 1 of this article and Annex 14B, expropriation. The language used here, which has rolled over from the 1992 NAFTA agreement, indirectly nationalize or expropriate, and a measure tantamount to nationalization or expropriation, clearly exists that compensation will be owed to de jure and de facto expropriation by the expropriating country. The scope of Article 14.8 is indeed wide. Measure includes any law, regulation, procedure, requirement, or practice, and the definition of investment is so expansive that it cannot be included here. Moreover, there is no allowance, as there is in Canadian common law, for express statutory language to extinguish the right of compensation. How the previous NAFTA Article 1110 has been treated in arbitration between the parties of NAFTA, Canada, the United States, and Mexico, has, or at least should have, bearing on expropriation law in Canada generally. This is particularly so given NAFTA's and now CUSMA constitutional-like status as a document which cannot be amended without the consent of all signatories. The NAFTA expropriation case that's received the most attention from Canadian legal scholars is probably Metalclad Corp versus United Mexican States, Metalclad. In that case, Metalclad had received approval from the federal government of Mexico to operate a landfill in the municipality of Guadalcazar and began to construct the landfill on that basis. Mid-construction, Guadalcazar informed Metalclad that it would require a municipal permit and must cease construction pending its issuance. More than a year later, Guadalcazar finally made its decision. Permit denied. The governor of San Luis Potosi, the state in which Guadalcazar is situated, further declared that Metalclad's land to be a natural area for the protection of rare cacti. The federal government took no saving action. In its decision, the tribunal stated, these measures, taken together with the representations of the Mexican federal government on which Metalclad relied, and the absence of a timely, orderly, or substantive basis for the denial by the municipality of the local construction permit, amount to an indirect or de facto expropriation. Its belief in the far-ranging scope of Article 1110 is evident. Thus, expropriation in NAFTA, and now CUSMA, includes only not open, deliberate, and also acknowledged takings of property, but also covert or incidental interference with the use of property, which has the effect of depriving the owner, in whole or in significant part, of the use or reasonably to be expected economic benefit of the property. Where the ratification of CUSMA will leave expropriation law and Canadian property rights in the future is uncertain. Time will tell whether or not the law will continue to afford foreign investors more protection than Canadians. And this is one example why a detailed analysis of the CUSMA agreement is so important for Canadians to understand what is being signed.
Questions and comments. Question commentaire. The Honourable Parliamentary Secretary to the Minister of Public Services and Procurement.
Yes, Mr. Speaker, very simply, obviously we on this side of the House believe strongly in the agreement that has been forged with our partners and allies, and note the concerns raised by my honourable colleague, and would just simply ask if she's that concerned about it, why is she voting for the agreement?
The Honourable Member for Renfrew-Nipissing-Pembroke.
Mr. Speaker, CUSMA validates my private member's bill C-222, and it naturally follows for C-4 that it also supports the same principles found in C-222, and that's why I am supporting this CUSMA agreement.
Questions and comments. The Honourable Member for Esquimalt-Saanich-Sooke.
Mr. Speaker, and I thank the member for Renfrew-Nipissing-Pembroke for her remarks. I always enjoy working